Welcome to the 2020 Hearing Officer and Tribunal Member Update. This update is sponsored by the Georgia Association of Educational Leaders and the Georgia Department of Education Policy Division. It complies with State Board Rule 160-4-8-.15, which requires that all educators who participate in tribunal hearings, or as they are known, due process hearings, those that participate are required to be trained once with a 5-hour training session, and then thereafter they are required to participate in an annual update. And this is the update for 2020. As of this date, and the effective date of this update is June the 1st, 2020, the General Assembly has not passed any laws that directly deal with student discipline. As you are well aware, the General Assembly has been out of session and will return to session on June the 11th. If the General Assembly passes laws which have implications directly dealing with student discipline, you will be informed of that at a later date. All of us are facing issues associated with the COVID-19 virus. Many school systems are concerned about students intimidating other students with possible virus contamination. You are advised to create a discipline code item that deals specifically with students that fail to comply with established health protocols and rules. This would include failure to wear required items such as face masks. As a discipline issue, this can be dealt with under insubordination, but it's much clearer and much easier to deal with if you have a specific item dealing with the health protocols and rules. One of the issues that students and school administrators have to deal with on a recurring basis is students that have been charged with felonies. The Georgia Code 20-2-768 is very specific about dealing with such students and those that have been charged with a felony committed outside the school environment. The law specifically dictates that students are to be placed in alternative school until they are adjudicated. All that is required is a letter from the superintendent to the parents of the student that has been charged with a felony, informing them that the student will be placed in the alternative school until such time as they are adjudicated. The parents or student may request a hearing, and in that hearing, all it's required is to demonstrate that the student has been charged with the felony, and therefore, by law 20-2-768, they are placed in alternative school until they are adjudicated. Once the student is adjudicated and found guilty of a felony, of course, if they are found innocent or the charge is reduced to a misdemeanor, then nothing is to be done and the student should return to school immediately. But if the student is found guilty or pleads guilty, a hearing should be held to determine if the student is permitted to return to the school, or if he is to be placed in alternative school or any other appropriate consequence. If the charges are dismissed or the student is found innocent, once again, the student should be immediately returned to their home school. Here are two cases which illustrate the implication of 20-2-768. In case A, student A is charged with grand theft but claims innocence. The school has no role in determining whether the student is guilty or whether they are innocent of the particular charge. The law applies to placing the student in the alternative school simply if they are charged. The student is placed in the alternative school until they are adjudicated. In this case, the student is permitted to plead guilty to a petty theft, which is a misdemeanor. He is no longer charged with a felony, and the student should be returned to school once the misdemeanor plea is accepted. Case B. Students B and C are dating, and B is charged with statutory rape. He is placed in the alternative school because he has been charged with a felony. The parents of C intercede with the court and have the charges dropped. Once the charges are dropped, the student should be permitted to return to school. Of course, the school may place the student under probationary conditions upon his return. Hearings for students that are to be sent to RYDC sometimes are problematic. There are no exceptions to the 10-day rule for the students being sent to RYDC. Schools are generally advised not to notify students that they are subject to a hearing if the student is being immediately transferred to RYDC. Wait until they get back from RYDC to tell them that they are subject to a hearing. Students should be informed of the hearing once they return to school. If the student is told that they are subject to a hearing as they leave to go to RYDC, the 10-day rule begins and the hearing must be held within the 10-day period, even if the student is confined to RYDC. Please be aware that if the school and parents agree, the hearing may be postponed until the student returns to RYDC. That, of course, can be eliminated by simply waiting till the student returns before you inform them that they are suspended subject to a hearing. Across the state, we're having some due process issues. Students may not be expelled or sent to alternative school without a due process hearing or a waiver of such. Administrators may not place a student in alternative school without a hearing or waiver. If that occurs, the student should be returned to the home school immediately when the situation is discovered. One of the most difficult issues that school administrators have to deal with on a recurring basis is the separation between special education students and Section 504 students. When a special ed student is accused of an offense that would result in due process hearing, the following procedure should be followed. First, a manifestation hearing should be held to determine if the alleged offense is a manifestation of the student's disability. If it is determined that it is a manifestation of the student's disability, the IEP has complete authority for a student if the student pleads guilty to the offense. If the student pleads not guilty, a due process hearing will determine innocence or guilt, but not consequence. Once again, if the IEP team or a manifestation hearing determines that it is a manifestation of the student's disability, then the IEP team will determine the consequence. If the manifestation hearing determines that the alleged offense is not a manifestation of the student's disability, the student goes forward to a due process hearing, and the hearing officer or the tribunal has total authority, including consequence. The special ed 10-day rule remains in place. Therefore, a student cannot be suspended or expelled out of school for more than 10 days per school year without being provided services by the school system. The third item of consideration is the special ed student's parents may sign a waiver just like any other student for the due process hearing, but they retain their special education rights, including the provisions of services under the 10-day rule. Section 504 students are very different from special education students. In fact, it's an entirely different law. Section 504 students arise out of the application of the Americans with Disabilities Act. Students provided services under a Section 504 plan are not special ed students and do not have the same rights and privileges and protections that a special ed student has. If a Section 504 student is charged with a violation of school rules that would result in a due process hearing, the following procedure should be used. The Student Section 504 Committee should conduct a manifestation hearing to determine if the alleged action is a manifestation of the student's condition. Regardless of the findings of the committee, the student goes forward to a due process hearing. The due process hearing, in the due process hearing, the tribunal or hearing officer is obligated to receive the report of the manifestation hearing and consider that report in determining the consequence for the Section 504 student. Section 504 students are not subject to the special education 10-day rule. So they may be suspended out of school for more than 10 days, or they may be expelled without the school system having the responsibility to provide services. Local school systems may grant special education rights and privileges to Section 504 students collectively. It is not advised, but it is done in many, not many, but some school systems throughout the state of Georgia. A controversy that exists in some school systems is when to hold the manifestation hearing. Some systems claim that we should have the manifestation hearing after the tribunal hearing is held, or that it should be held as a part of the tribunal hearing. The federal IDEA regulations require that a manifestation hearing be held within 10 days of a student being informed that they are subject to a due process hearing. Systems are strongly advised to hold the manifestation hearing prior to the due process hearing so that the hearing officer or tribunal will know the extent of their authority. If the manifestation committee rules that the alleged action is a manifestation of the student's disability, the hearing officer or tribunal is authorized only to determine innocence or guilt, not consequences. If the committee rules it is not a manifestation of the student's disability, the hearing officer or tribunal will determine innocence or guilt and consequences. So holding the manifestation hearing prior to the due process hearing clearly determines what the authority of the hearing officer or tribunal has with regard to the case. We continue to have issues with weapons being brought to school. I want to call your attention to Official Code of Georgia 20-2-751.1. Each local Board of Education shall establish a policy pursuant to this subpart regarding a student's possession of a firearm, dangerous weapon, or hazardous object at school. With respect to a student who is determined to have possessed a firearm or dangerous weapon at school, such policy shall require expulsion from school for a period of not less than 1 calendar year, provided, however, that a hearing officer, tribunal panel, administrator, superintendent, or local board of education shall have the authority to modify such expulsion requirements on a case-by-case basis. Schools must conduct a hearing for all weapons cases, simply because of the fact that you have to, the 1 year calendar expulsion must be recommended by the school. But then once it is recommended, then the hearing officer, tribunal, superintendent, or others can make an exception that ranges from time served to the full year expulsion. Schools are not advised to use waivers for weapons cases unless the superintendent is involved and approves the case-by-case exception. Students often transfer while they are under disciplinary sanction, particularly in the situation where a student is informed that they are subject to a due process hearing and the parents announce that, well, I'll just withdraw my child and we'll move to another school system. That is certainly permissible under state law. Students may withdraw and transfer at any time. If the student has been told that they are suspended pending a hearing before they withdraw, the school must go forward with the hearing and notify any school that the student transfers to of the consequences of the hearing. The receiving school must honor the discipline imposed by the sending school. So if you expel them with the opportunity to attend the alternative school, they have to go to the alternative school at the receiving school. If the student is not notified of the suspension and or hearing prior to withdrawing, the school has no jurisdiction over the student and therefore may not proceed with a hearing for the student. An example of this is that a major fight takes place on a bus on Friday afternoon. The principal is not notified of the situation until Monday morning, but early Monday morning, before he is notified of the incident on the bus, The student's parents come and withdraw the student from school. And then the principal finds out about the situation after the student has withdrawn. In that case, the student cannot be held to a hearing because the student has withdrawn prior to being notified. Students may claim self-defense if they are charged with fighting. Under the provisions of SG versus Henry County, students that are charged with fighting may plead self-defense, but the student is responsible for proving that they fought in self-defense. It is not the responsibility of the school to establish that proof. The hearing officer or tribunal should consider the plea of the student claiming to have fought in self-defense and then render a decision based on all of the facts of the case. But once again, the students may claim self-defense, but they must prove that they fought in self-defense. Every year we have issues associated with charter school students being dismissed from charter schools or being expelled from charter schools. Students enrolled in local charter schools or state charter schools that undergo disciplinary sanction at the charter school and leave the charter school to return to their home school are subject to the sanctions imposed by the charter school. It is a problematic issue if the student is dismissed from the charter school and told they must return to their home school. A student that is denied enrollment by a charter school, either by dismissal or expulsion, is not eligible to enroll in any other public school. Please consult with your school board attorney before permitting a student dismissed from a charter school to enroll at your school. Please be reminded of the stipulations that are required if a student is to be called as a witness in a hearing. Before a student can be called as a witness in a disciplinary hearing, the parent must be notified and informed that they may accompany the student to the hearing, may advise the student during their testimony, but may not speak in the hearing unless permitted to do so by the hearing officer or chair of the tribunal. The parent does not have the authority to deny the student from testifying in the hearing. If the parent attempts to deny the student the opportunity to testify in the hearing, then the student may be subpoenaed in order to get the student to testify. Students that are called as witnesses or subpoenaed by the student's parents are not subject to this regulation. Again, if the student who is basically the defendant in the case wishes to call students to testify on their behalf, they are not subject to the regulation of notifying the student's parents. Every school system has to deal with discipline with students in grades K through 3. And the incidence of serious discipline infractions in grades K through 3 continues to increase. Students in grades K through 3 may not be suspended out of school or expelled for more than a total of 5 days per school year unless the MTSS process has been instituted for the student. There are no exceptions to this rule, so please make sure that before you suspend a K through 3 student out of school for more than 5 days per school year, that's cumulatively 5 days per school year, that you have begun the MTSS process for that student. State Board Rule 160-4-8-.15 requires that all persons that participate in a tribunal, either as a tribunal member, tribunal chairperson, or hearing officer, undergo an initial 5-hour training covering specific topics. Each year thereafter, the trained educator will be required to participate in a training update. Administrators that present at a tribunal hearing are not required to undergo the training, even though such training is advised for such administrators. Once you have completed this update, please email Jimmy Stokes at jstokes@gael.org to report that you have completed the update training. You will receive a confirmation confirming your certification to participate in hearings for the 2021 school year. Please be advised that you are welcome to contact Jimmy Stokes at 770-601-3798 for advice regarding disciplinary hearings. There is no charge for this service. It is provided to you by the Georgia Association of Educational Leaders. This concludes the update for the 2020-2021 school year.